Mr. Zhulkarnain bin Abdul Rahim.
Mr. Deputy Speaker, according to a World Bank Group report on cost-benefit analysis of legal aid, the world faces a widespread justice gap. Globally, billions of people lack access to basic justice services, and the most vulnerable are often women, children, people with disabilities, and people from minority ethnic communities. It is thus important to address this justice gap. While Singapore has a leading legal system and great access to justice already, we must continue to ensure that the most vulnerable segments of our society get the fair representation that they deserve in our criminal justice system, which is why this bill is important. I welcome and stand in support of this bill, and I would like to applaud MinLaw for this step towards greater access to justice. In Malay, please. Pada Oktober 2020, saya bertanya sama ada pemerintah akan mempertimbangkan untuk memberikan bantuan guaman langsung kepada golongan yang tidak mempunyai kemampuan kewangan dan yang telah didakwa atas kesalahan jenayah. Ini berikutan kebimbangan yang dibangkitkan mengenai akses kepada keadilan dan perwakilan yang mencukupi berikutan kes parti liani. Rang undang-undang ini membolehkan akses kepada keadilan untuk kes jenayah. Sebelum ini, bantuan guaman jenayah ditadbir oleh Persatuan Undang-Undang sahaja. Berdasarkan pengalaman saya sebagai peguam bela sukarelawan dengan Biro Bantuan Guaman dan Kelas, saya mengalu-alukan bantuan guaman sementara dan proses kelulusan bantuan oleh lembaga pejabat pembela awam. Saya juga mengalu-alukan skop kerjasama dan perkongsian kes antara PDO yang bakal ditubuhi dan kelas yang ditadbir oleh Persatuan Undang-Undang. Kerana ini akan membolehkan orang tertuduh mendapat perwakilan undang-undang serta kepakaran yang berpatutan. Dengan penubuhan pejabat pembela awam, saya berharap lebih ramai tertuduh boleh mendapat akses kepada perwakilan yang adil dan sama rata di mahkamah, tidak kira kedudukan, status atau kemampuan mereka. Mr. Deputy Speaker, providing criminal or civil legal aid requires funding and resources. However, there is also an economics argument to improve access to justice in society. In Canada, the cost of unequal access to justice on public spending in other areas like social assistance and healthcare costs had been estimated to be about 2.35 times more than the annual direct service expenditures on legal aid. In Australia, studies have shown that there are net public benefits from legal assistance expenditures. Investments in legal aid can lead to significant government savings through avoided cost of arrest, conviction, incarceration, probation, and post-prison supervision. In addition, public investments in legal aid are also found to generate net savings in terms of avoided shelter or housing costs. Now, for one to qualify for PDO aid, one would have to pass the means and merits test. I have a few clarifications in this regard. Firstly, on the merits test, I welcome the expanded means criteria that SPS mentioned just now. Already, it is higher than the civil legal aid criteria of $950. Specifically on PCHI and definition of household members, I would like to ask, will there be discretion on the part of the Chief Public Defender, CPD, to grant criminal legal aid if accused person, AP, is no longer residing in the household, but the NRIC reflects the same address? How about APs who can actually afford private lawyers because their children can pay, but their children are not living with the AP? I echo Honourable Member Lim Biao Chuan's concern that there is need to safeguard against abuse of process. It is important to clarify that passing the means and merit criteria does not automatically mean criminal legal aid will be granted. PDO or CPD shall still retain discretion whether to issue grant of aid or not. Hence, I welcome Clause 12, subsection 1D, which retains such discretion, and this will cover the exceptional cases and prevent the decisions of CPD from being challenged unmeritoriously. To illustrate this point, in October 2021, a US couple sued the Colorado Public Defender's Office for refusing to represent them in a criminal case. Now, both of them earn less than $3,000 a year, which automatically qualifies them for a public defender under the Colorado Supreme Court's guidelines. In Singapore, this may not be challenged because of the proposed Clause 12, subsection 1D. Secondly, with regard to the merits test, CPD can award aid if he is of the opinion that AP requires legal representation to plead guilty as stated under Section 12C. However, what about a straightforward plead guilty case where the AP would require legal assistance to formulate a mitigation plea, for instance, for appropriate sentencing? I propose that for such cases, it should be granted because firstly, it will save time and resource for both AGC and the CPD if issues on sentencing are appropriately addressed. And secondly, it will be just if the appropriate sentencing is meted out if the necessary mitigating factors are highlighted. Next, in respect of co-accused situations, now Clause 14 prevents the PDO from acting for more than one accused person. This is rightly so, to prevent conflict of interest. However, how will PDO ascertain which accused persons that PDO will represent? What will be the criteria? Is it the one with the best merits, the one with the lowest means, or the one that's first in time of application? In instances where it's equal and the co-accused person is deserving of representation, I welcome Honorable Senior Parliamentary Secretary saying that PDO may assign the case to class. I hope it will be the same for the other co-accused persons as well. Next, in relation to offences involving false or misleading statement, the offences and penalties proposed under Clause 23 of this bill is the same as that of Section 21 of the Legal Aid and Advice Act, in that both carry fines of $5,000 per contravention and imprisonment of up to 6 months. May I ask, what is the rationale of having similar penalties? Would not the breaches under the Public Defenders Act be more egregious and thus should attract heftier penalties as a deterrent, given that, firstly, it amounts to a perversion of criminal justice, secondly, it mainly involves matters of policy and public interest as opposed to civil claims, and thirdly, it involves wastage of public resources. Lastly, I would like to highlight the important role that PDO plays in portraying the image and integrity of Singapore's criminal justice system, and therefore it is very important to look into the following aspects. The first is the practice of plea bargaining, which is practiced in Singapore and may generally occur once an accused is charged. The outcome of any plea bargain depends on various factors, including public interest, timing of the guilty pleas, and so on. It is important to note that while a guilty plea saves public resources, a plea bargain is not a given right. In the US, the vast majority of felony convictions are now the result of plea bargains, some 94% at the state level, 97% at the federal level. Very few cases go to trial. US Supreme Court Justice Anthony Kennedy once wrote, and I quote, "Horse trading between prosecutor and defense counsel determines who goes to jail and for how long." That is what plea bargaining is. It is not some adjunct to the criminal justice system. It is the criminal justice system, unquote. The situation in US is possibly due to a disparity in funding of the two sides of the criminal justice system. Of the US $200 billion spent on criminal justice activities by state and local governments in 2008, only 2% went to indigent defense. There was also lack of training and support for overworked public defenders, and a lack of reform to the bail system, which holds people in jail simply because they lack the funds to secure their own release. Now, in Singapore, with the establishment of PDO, it is important to ensure that our system does not devolve into a similar scenario like that in foreign countries. I would propose for safeguards to be put in place to ensure that any plea bargain entered will be in the best interest of and AP. And perhaps these cases may have an avenue for review by an independent body with MinLaw and law societies' involvement. I echo Honourable Member Murali Pillai's suggestion for publication of KPIs. I would like to propose for such transparency, whereby there is public publication of annual report of statistics of PDO cases that went to trial, number of APs assisted, and conviction rates if possible. Next, on avenue of redress, if complaints are raised about PDO officers, to which body would these complaints be referred? For private or class practitioners, they are governed under the professional conduct rules and referred to the Law Society. My next point is on building up the capability of PDO officers. It is imperative that we attract and retain talent in PDO. To ensure that there are PDO officers with the appropriate trial experience, I propose a secondment of AGC officers to PDO and for active recruitment from the criminal bar. We need to dispel the myth that public defenders are not going to give a fair representation of any accused. In fact, the converse may be true. Studies show public defenders perform better than the appointed counsel, i.e. those who are counsel in private practice and paid by the system. In an article published in Yale Law Journal, which involved a study of almost 2,500 cases in Philadelphia, it was found that in comparison to appointed counsel, public defenders had reduced the client's murder conviction rate by 19%, lowered the probability that the clients receive a life sentence by 62%. Public defenders also reduced overall expected time served in prison by 24%. There were two factors that interviewees cited as important differences between public defenders and appointed counsel. Firstly, public defenders' use of integrated teams, which means greater access to non-legal professionals who may help in the defense. And secondly, the larger amount of case preparation by public defenders. What this means is that a robust training will create more opportunities for our PDO officers. Firstly, they will be able to handle more cases, and this will enable them to build up their specialization and hone their skill sets. Secondly, they will have greater access to resources to aid them in the defense of APs. In terms of specializations, perhaps there could be a setting up of dedicated teams within PDO like that in the AGC arranged according to the types of offenses so that PDO officers can build up deep capability and skill sets. And secondly, a platform for the cross-training and sharing of ideas between prosecutors, PDO, and the criminal bar. In conclusion, Mr. Deputy Speaker, sir, with the setting up of the PDO, we will have greater access to criminal justice for the public and build skill sets and experience deep enough to prepare us for tomorrow. I stand in support of the bill.